Hello, I'm Jim Dirman. I'm a criminal defense lawyer in Sarasota, Florida. Thanks very much for logging on to my website. I'm pretty sure that you have some interest in criminal law and perhaps even hiring a criminal defense lawyer. And that's why I put together this video. The purposes of the video are twofold. First, to talk to you about the basic principles of criminal law, what you might expect to find if someone you love or yourself has a criminal defense problem. And second, to introduce myself to you and to let you know who I am, what my experiences are, and perhaps you'd be interested in talking with me about your case. The fundamental principle of criminal law in the United States and in the state of Florida is that if you're accused of a crime, you're innocent until proven guilty. In addition, you have many significant, important rights. Those include the right to reasonable bail, so you can be released from custody. The right to hire an attorney to represent you and to be with you throughout each stage of the proceedings that will be part of that case. You have the right to remain silent so that you are not compelled in any way to be a witness in the case. Although you can be a witness, the state cannot force you to be a witness. And that includes your right to remain silent as far as giving any information or statements to law enforcement agents. There are additional rights, including the right to discovery, meaning getting important information from the state, which would include witness lists, the names and addresses of those witnesses, statements of the witnesses, information that was compiled by law enforcement regarding times and dates, medical records, other documents, electronic records, phone records, text records, those types of records that could contribute to the prosecution or hopefully to the defense of the case. Another fundamental right is the right to have a jury trial. In Florida, that jury is generally composed of 6 citizens unless the charge is a capital crime, and in those instances there is a jury of 12 persons. And maybe the most important right is the right to cross-examine witnesses. This is a fundamental right that's been handed down from the very beginning of our country, and it is essential in determining the credibility and the truthfulness of witnesses who might be brought against you. And that is a critical right that you have. And finally, the right to have a jury decide whether you are guilty or not guilty beyond and to the exclusion of any reasonable doubt, which is a very high standard of proof. Criminal law, of course, deals with an individual being charged with a crime. And that then implicates many aspects of that person's life, their job, their family, their friends, associations that they're involved with. Because in today's world, the act of being arrested or charged with a criminal offense generally hits the internet through either an arrest mugshot or the probable cause affidavit alleging the crime or some other part of the case that will get out into the cyber world. And therefore, just about anybody that's interested in you can find out about that case. So in the pre-computer era, it could be sort of a local issue and only certain small group of people would know about it. Now that has all changed. On the other hand, the civil law and the civil case is entirely focused on money and property and who owes who money, and if someone injured someone, how much money will it take to recompense that injured person. So in evaluating the importances, clearly if you are the subject of a criminal charge, this event could change your entire life and your future. That's the stakes, and those are quite different from the stakes that are at issue in a civil case, because generally people can always earn some more money, they can always buy some more property, but once you lose your reputation or your freedom, it's very difficult to get it back. Well, of course, the prosecutor is a state employee, and in our jurisdiction, that means an assistant state attorney. That person is a employee of the state. They are charged with investigating crimes and bringing charges if there is appropriate evidence to prove the crime. Their burden of proof is very high. They have to construct a case that can withstand all creative attacks. On the other hand, the defense lawyer and the defendant have no burden of proof. Now, that's not to say the defense can't come forth with evidence and witnesses and documents, because we can. But the law doesn't require that of us, and many criminal cases are won strictly on the basis that the state has failed to meet its very high burden of proof. And so the analogy that I like to use is the state has to build a really big, beautiful building as its case. On the other hand, the defense rolls up in a big wrecker with a big wrecking ball, and the defense is trying to put holes into that building that the state built. And so if the defense is able to create reasonable doubt through this effort, that is what the mission is, to show that that case of the states is not supported by evidence proving guilt beyond any reasonable doubt. When I was getting out of high school, I was interested in the military. I thought perhaps I would make a career out of that. My dad was an officer in the Army in World War II, and I had already always admired military veterans, and I wanted to join the military. And I liked the U.S. Marine Corps, and so I enrolled in a program called the Platoon Leader Course, PLC program, which involved a 7-year commitment, 4 years in the reserves, and then when I graduated from college, I received a commission as a second lieutenant. Once I got through with my basic training in the Marine Corps, I happened to time my service with the Vietnam War. So I was a member of a Marine Artillery Battalion, the 4th Battalion, 11th Marine Regiment, that was deployed to Vietnam in 1966. And I saw combat in Vietnam with that group, and I also was a officer with the Korean Marine Brigade in Quang Ngai, Vietnam, as a Marine advisor. And so my experience in Vietnam and having people shooting at me and my fellow Marines gave me a sense of what it means to have a dedicated and well-trained enemy trying to kill you. And that experience has served me well as a criminal defense lawyer, because in many ways, going into court, sitting next to a person charged with a serious crime, has the same objective: survival. We're trying to survive this attack from the state, and it's about as close as you can get to military combat. When I came to Sarasota after law school, I joined a very good law firm here in town, and after about a year I decided I wanted to become a state prosecutor, and that occurred in 1971. I was assigned to the felony division of the prosecutor's office, and in the time that I was there, I prosecuted cases ranging from what they called then rape, which is now sexual battery, and robbery, burglary, fraud cases, drug cases, and many other types of felonies. So I got a tremendous ability and training to do criminal cases, how you put them together, how you prosecute them. And I learned that as a prosecutor, it's oftentimes difficult to meet that heavy burden of proof beyond any reasonable doubt.
Can you give us an example of some criminal cases and what were the winning elements of those cases?
I have had many cases, and some stand out in my mind. For instance, a attempted murder case involving a robbery where I was in court and the prosecutor brought in a witness who we really didn't think was necessary, but she was a diligent landlady and she was checking on the rent. And the reason for bringing that witness was because the state wanted to prove a motive, that our clients hadn't paid the rent, needed money. But what the state didn't see was that this witness was there right on the date of the robbery and had seen a vehicle relating to another person, a brother of the co-defendant, who we said was actually the robber. And so that brother had claimed through earlier statements that he was in Tampa or some other place on this particular day. But here the landlady came in, unbeknownst to us until the trial, and gave us a gift that, hey, this person we say committed the robbery, his car was parked in the driveway a few blocks away from the robbery. That plus some other important gifts that occurred in that case led us to a not guilty verdict. Because of that high burden of proof that I've referred to, the proof beyond any reasonable doubt, one significant chink in the state's case, depending on the jury, can be enough to create the concept of reasonable doubt. Let me give you another example. You'll all remember the name John Connally. He was with President Kennedy in Kennedy's vehicle when the president was assassinated back in 1963 in Dallas. Well, John Connally went on to become Secretary of the Treasury, and he was indicted for receiving, quote, unlawful gratuities, which means bribes. And the key witness against John Connally was a man by the name of Jake Jacobson. Jacobson had given a story initially to the FBI that he, Jacobson, was the person who transferred the money, and he used a rubber glove, to count all this cash. Well, when the case got to trial, Jacobson got on the stand and changed his story and said at the trial he had used rubber gloves. So the defense lawyer, a very famous lawyer by the name of Edward Bennett Williams, cross-examined Jacobson and said, why did you change your testimony? You said glove to the FBI, but now you're saying you use rubber gloves. Because obviously it would be kind of hard to count a bunch of money with one rubber glove. And Jacobson said, well, the reason I changed my testimony was it sounded more logical that I was wearing rubber gloves. That, plus a couple of other small inconsistencies, led to an acquittal of John Connally, the former Secretary of Treasury, one of the highest positions in American government. So, an open window, a closed window, what a person does when they look into a door and see someone committing a crime, and then close the door and casually walk away, but then come to court and claim that they were outraged and this was a huge crime that they observed, yet their actions belie what they're saying. No reasonable person would do what they say they did. So many small, apparently unimportant details can actually win the case. Well, with the advent of computers and iPhones, we're seeing more and more electronic evidence. And of course, law enforcement is used to getting that evidence and examining that evidence and using it against you. But sometimes the electronic evidence can be very helpful. So the state may want to concentrate on certain information, Skype, Facebook, chat messages. But if you look and you do your own investigation through probably a forensic expert, you may find other chat, Facebook, Skype, text messaging that undercuts what they're saying. And so sometimes that evidence can be very beneficial to the defense. In addition, I like to use videotape depositions, and a deposition is nothing more than a one-on-one interview with a witness. But if you have a video, you can then play certain portions of that video in court. And like anything, it's much more powerful, much more dramatic if you can pop up on a large screen this very witness who has said, well, no, I didn't do that, and now you have them saying under oath on the video, they did do that, just the opposite. And you get the sense that, aha, you can't trust this witness. If they lied about that, what else are they withholding? And you undercut the credibility, and if that's a key witness, that might be enough to win the case. Well, obviously, there's a lot of lessons to be learned. Certainly, one of those is preparation, preparation, preparation. The other lesson that I think I really have adopted is that when it comes to jury trials, people the jury like have a lot of rights. And on the other hand, people the jury don't like have very few rights. And so the presentation, the dress, the manner of speech, the courtesies, not being obviously angry and outraged, being appropriate in the courtroom is so important to how that jury sees the person, especially the defendant, and the assessment and evaluation the jury is making. Do I like this guy? Is he a good person? And no one is really saying that's how they're evaluating the case. But really, if they don't like the person, it's going to be hard to find reasonable doubt, even if it does exist. Well, I have been board certified as a criminal defense trial lawyer since 1987. That's a distinction that the Florida Bar has given to me because I met the qualifications for that certification, and then every 5 years since 1987 I have been recertified up until the present time. So for 25 years I've been looked upon as an expert specialist in this area of the law, criminal trial law. And again, to maintain the certification, you have to have peer review of other lawyers who have dealt with you, who have taken your word, who have trusted you, who have seen you in action, who have watched your cross-examination of witnesses. And there are requirements of peer review by judges who have sat up on the bench and watched you handle a case and seen you in action. And so if your abilities have faltered, or you are unethical, or you don't know what you're doing, you're not going to become or maintain your status as a board-certified criminal trial lawyer. The National Trial Lawyers Group has designated me as one of the top 100 trial lawyers in Florida. I put that link on my website so you can go and visit that and take a look for yourselves what that means. And again, you have to understand that in Florida there is a huge number of lawyers, and we are, I think, exceeding 90,000. So that is a distinction that I'm proud of. The peer review gold standard in the practice of law is done by Martindale Hubbell. It's a company that's been around for about 90 some years, 94 years. And they rate lawyers through peer review. Their highest rating is AV, and what that stands for is the highest rating in legal ability and the highest rating in ethical conduct. And I have held that rating for a number of years and hold it right now. I've also been the president of the American Board of Trial Advocates, a very select group of trial lawyers. That presidency was for our chapter here, the Sarasota-Bradenton chapter, and I enjoyed doing some seminars with with that group and going out to California as a representative of our group here in Sarasota. I've also received an award from the Sarasota County Bar Association called the James Slater Professionalism Award in Criminal Law, which is an honor from the group of lawyers here that I practice with every day. And I also have received an award from the John M. Shebb American Inn of Court for professionalism, and that is another group of lawyers who are well regarded and who have bestowed that honor on me. So I'm proud of all of those things, but probably the thing I'm most proud of is being a lawyer and being able to represent clients who need help. Well, usually I hear from people by a phone call or sometimes by email. And as soon as I make contact with them, I'll talk and find out a little bit about them and their case. And then if they're interested in talking to me about representation, I'll ask them to come to my office here in Sarasota and having a confidential, private conference in my office to discuss the details of their case. What really happened, who are the witnesses, what is the evidence, what are they looking at in terms of charges, what are their various options, and what are the fees and costs that would be involved for me to handle their case and represent them. And that particular initial conference is no charge, no obligation. I'm happy to do it for people whether they hire me or not, because then they'll have a benchmark of perhaps talking with other lawyers and they can make a good decision. Which lawyer do they feel comfortable with? Which lawyer will be best to represent their interests in their particular case?
What would you consider to be the most important aspects of the attorney-client relationship?
From my years of experience, I think there's two things that are the most important. The first is really good communication. And I know people talk about that all the time. But it's one thing to talk about it, it's another thing to do it. And I try to go overboard in communicating with my clients. And that doesn't mean just a phone call or a text or a letter. The best communicating with the client is face-to-face in the office with no distractions, so the client can ask all the questions that he or she has, and I have the time to answer those questions completely. And if they're not answered completely, we'll have another session to do it so they understand what they're looking at. Because many times in these criminal cases, the lawyer has to be honest with the client and tell them, look, this is a difficult situation that you're in. These are your options. And ultimately, the client and the client's family have to get together and make those difficult decisions. And it's the lawyer's job to help the client make those decisions, not to make those decisions for the client. And the other aspect that has to be there is what stems from the good communication, and that is trust and confidence in this man, the lawyer, that he is doing everything that he can to help me, to represent me, but also to tell me the truth. Where do I really stand here, and what are the consequences of my decisions? And in some instances, they can be very daunting and very scary, and the client has to believe the lawyer is giving him the straight information so that the client can then go and think about it and ultimately decide, yes, I want to take my case in front of a jury. No, I want to make some kind of a deal with the state.